Hello everyone, I'm Dr. Kalpana. Today we are going to discuss about government contracts. Government contracts are important in modern times as state increasingly acts as dispenser of wealth through contracts, licenses, jobs. So these are when it comes to entering into an agreement with central government or state government is entirely a different matter and procedure. So expansion raises concern about arbitrary power which necessitating norms to regulate government discretion and protect individual interests. So a contract is largely enforceable agreement creating personal rights and obligations. Government contracts involve center or state government as party and must comply with the specific constitutional provisions to be valid instead of following Indian Contract Act when it comes to there is one party which is either a central government or state government. So, what is the legal framework of government contracts? So, contract definition has been provided under Section 2H of Indian Contract Act, which defines it as very simple an agreement enforceable by law. Enforceable by law, there are tests for legal validity, which we have discussed in other videos. Government contract, so a contract which involves the central government or the state government is government contract as one of the party, and it must comply with Article 299 of Indian Constitution, which prescribes formalities for validity. One thing is important to understand here. So far as test of validity is concerned, it would remain the same with all contractual relationship. But when it comes to entering into any business contract with government or an employment contract, then negotiation power with the individual, private individual is sometime unfair or sometime may not be that consensus ad idem which we talk about when two or more parties are agree in the same sense on the same thing. Historical and constitutional context of this kind of provisioning in law is British position. If we talk before 1947, Crown could not be sued for contract protected by principal king. There's a principal king can do no wrong. As we talk in management language, boss is always right. So king used to be the boss of everyone. But since we adopted democratic process through our constitution, so this saying king can do no wrong is obsolete. So the Crown Proceeding Act 1947 changed this, allowing suits against the Crown. And now talk about Indian position. Indian Contract Act allows oral written contracts, but government contracts must meet Article 299 requirements. So Supreme Court confirms government contracts are governed by contract law and constitutional formalities. As I told you, when it comes to other tests and principles of a valid contract, we have to refer definitely Indian Contract Act 1872. But when it comes to the process, procedure, and formalities, we have to refer Article 299. So keep in mind, Article 299 is important when it comes to the question of government contract. What Article 299 is all about formation and formalities expressed by President, Governor, President for central contract and Governor for state governments. So contract must be expressed to be expressed made by President or Governor, depending upon whether it is a central or state government. Executed on their behalf, contract must be executed on the behalf of president or governor by authorized persons on whose behalf they are working. Authorized execution manner and person executing the contract must be authorized by the president or the governor. The power is coming from the office of the president or governor on state level. Implied contracts and judicial flexibility. No implied contracts when it comes to government contracts, as we have studied in law of contract. If someone is performing the conditions of contract, it is called implied contract. But when it comes to government contract, Article 299, subclause 1 forbids implied contracts with government to prevent bypassing formal requirements. So there is no possibility of other kind of private contracts like between A and B or XYZ. Judicial balance, court balance, protecting government from unauthorized contracts and safeguarding private parties who may lack formalities but acted in good faith. So this is depending upon the judicial understanding and discretion when it comes to any dispute between a private individual, company, or a business house and dealing with the government in contractual relationship. Substantial compliance. So, contract with substantial compliance to Article 299 may be enforced, easing administrative burdens of strict formalities. What are the principles underlying government contracts? So, reasonableness and fairness, which is a general principle of law which is applied everywhere. Government actions must be rational, non arbitrary, and fair, reflecting the rule of law and equality under Article 14, on which judicial approach is applied on these principles. Public interest is something which is very important. Government as well as the private individual or any company or business house has to ensure when it comes to government contracts are concerned, there is a matter of public policy and public interest. So, contract involving public property must prioritize public interest, avoiding bias, nepotism, or unfair discrimination. These are also the grounds and principle when it comes to testing the validity of uh, government contracts. Equality and non-arbitrariness. Equality opposes arbitrariness. Government contracts must meet standards of reasonableness and non-discrimination. So these are the basic principles, fundamental principles uh, which are related to government contracts. Contractual liability in Section 70. So Article 299, subclause 2, immunity that has been provided. President, governor, or authorized persons are personally immune from contract liabilities, but government remains liable. Personally means, for example, Draupadi Murmu cannot be sued personally, but that government would be held liable if there is a breach of contract. Section 70 protection. If government benefits from an invalid contract, it must compensate under Section 70 to prevent unjust enrichment. So government has to compensate if there is invalid contract. Quasi-contractual claims. Section 70 of Indian Contract Act supports claims for reasonable compensation when formal contract requirements are unmet but benefit is received. Judicial review of government contracts, fairness and non-discrimination. A government must contract fairly without bias, arbitrary decisions subject to judicial review under Article 14, which talks about right to equality. Right to equality are two kinds of equality expressions are provided under Article 14, equality before law and equal protection of law. Review limits, court review decision making process, not contract merits, ensuring reasonableness and absence of malafide. So, balance of discretion, judicial review respects government discretion Within reason, decisions outside reasonableness are ultra wires and subject to question, depending upon if there is any ground on which uh, that principle is not applied or validity of the contract test comes, then it can be questioned also. So that was all about government contract. Just a quick recap about understanding government contract. First of all, just keep in mind two subclauses. Article 299 subclause 1, Article 299 subclause 2, Section 2H, which defines valid contract and agreement enforceable by law, and Section 70 talks about the liability in contracts. So thank you so much. Have a good day. Happy learning.